Our good friend, my life consultant, legal correspondent, best friend and gambling buddy, Jay St. Clair, joins us on our weekly visits. Hello, Jay.
Hey, Matt.
How are you?
You know, the only way I think I could be any better is if I were shotgun.
Yeah.
That would be good then.
I wonder if she's listened to the show at all since she's been to Nashville. I don't know.
Well, I sent her a note. Bill, you probably don't know. Have you heard us talk about shotgun?
I don't think we have. I don't believe so. Of her.
Yeah, Shotgun is my daughter, and that's her nickname. Here's all I can tell you about her nickname. So she went off to college, and then they have these thing called parent days, right, where the parents go down and see them. So her mom went down to see her on Parents' Day, and went to a fraternity. I think it was a fraternity, maybe a joint fraternity sorority thing, but all the frat guys were around. You know, and so she goes up and she's talking to these frat guys and asks them who they are and so forth. And they ask her, who are you? And she goes, well, I'm Lauren's mother. You're Shotgun's mother?
They called her Shotgun. The frat guys called her Shotgun.
And that's all I know about it. I adopted a don't ask, don't tell policy about that.
Have you been told?
Probably for the better.
Have you been told, Jack?
No, I don't know if her mom talked to her about it. I don't know.
Mm-hmm. Oh, I know. I can give you a pretty good guess. Has to do with a beer and a nail.
So you were talking about staying hydrated? It may have something to do with that.
I think so. Well, I've never understood why they tell us that beer will not hydrate you, because it has to have water in it, right?
Yeah, but
I mean,
well, it's like Archie Bunker said: you don't buy a beer, you only rent it.
Well, that's
my daughter Shotgun Bell just moved to Nashville.
How about that? So
how old is she?
Too young for you.
How old?
too young and too pretty. Well, is she? How old is she, Jay?
She's 30.
30? Yeah. Shotgun's 30? Wow.
Yeah.
Well, Jay's 74.
You hear that, Jay?
No.
He said Jay's 74.
Well, it's 60. When I'm 64, Bill, you should know your Beatles better than that.
Well, it's good to talk with you. We got lots to get into, and I hope Shotgun's listening. And if she is, thank you for listening, Lauren. We appreciate you. So, Jay, where you want to go first on the Supreme Court? I'm gonna make it dealer's choice. Because I know you've kind of followed some of these rulings. We didn't get all of them. They've still got several. I guess, are they required to issue their rulings before the end of June, before the end of session? Is that right?
You know, there's not an official date about that. That's kind of the tradition. The first Saturday in October, I think by law, is when their session starts, Matt. But I'm pretty sure there's no law that has the official end date. But for a long, long time, they have always concluded their regular docket by June 30th.
Mm-hmm.
And there's no reason to think this will be an exception. So, yeah, the next couple of weeks, there's going to be some big decisions coming up.
Well, and one of them is obviously the immunity issue, and maybe before we get done here, I can ask you what you expect to come out of that. But dealer's choice, Jay, which one of the ones that we've heard about coming out is of most interest to you?
You know, the bump stop thing, I heard you had a guy, what was his name?
Brink Fiddler.
Well, Brink has said it all. I mean, golly, I want to hire that guy to be in my law firm. He very well spoken and exactly, he hit the bullseye.
Yep. Oh, yeah.
Did there.
I saw what you did.
But, yeah, it's actually a pretty simple case. It's not a case about the Second Amendment at all. It's just a case about interpreting a statute. And it was not a hard job. I mean, the statute is just defining what a machine gun is. And the definition is that when you pull the trigger once, it just keeps shooting until you take your finger off the trigger. There's no other trigger action needed. Well, that's not what a bump stop does. And Brink explained that. I mean, the person doesn't have to manually do it with their finger, but the trigger is actually moving back and forth.
Right.
It's just a matter of statutory interpretation. It gets into this bigger issue that, just wears me out, where Congress keeps ceding its authority to the administrative part of the executive branch. They pass these laws, and then they say that the Bureau of Tobacco and Firearms can issue regulations. In effect, they write the laws, and that's not the way it should be. And this is another example of this. But here, the Supreme Court said, no, we're not going to let you rewrite this law. If Congress wants to change it, they can change it.
Well, and it's an interesting, and I know this is more my world than your world being the legal world, mine being the political world, but I find it amusing that it happened during the Trump administration, so it is considered a Trump era ban, and the 3 liberal judges on the court ended up agreeing with the Trump administration on the ATF's interpretation during Trump of what they could or could not do with regard to the term machine gun.
What's the phrase, man? Politics makes for strange bedfellows.
Mm-hmm.
I was thinking about that recently. A name has surfaced for Trump's VP pick, who was actually the guy, you might remember this, back in 2016 when the race was first starting. This is the guy I liked instead of Trump, Marco Rubio.
Marco Rubio.
I still have the recording of when they were in the debate, and Trump kept calling him Little Marco. Little Marco.
He's changed his tactics. He's not doing so much of that. And I guess probably it's a byproduct of not having to go through the primary process, but we've not heard so much of that out of Trump lately. But I kind of loved that dark Trump, where, he would come up with some of the Little Marco.
And the funny thing is people didn't really know how to handle it. I've got the recording. I send it as a little voice memo to Buddy Gerald from time to time. And Marco, it caught him off guard. He didn't know what to do, man. So he was going to come back with, well, okay, Big Donald. And then he caught himself kind of mid-sentence and says, that's really not a cut. I'm not going to call him Big Donald. Very fun.
No, Little Marco. Well, so, obviously, it's a clear-cut case of, and you've talked about this over many years, that in our lifetimes, we've seen more and more of Congress not wanting to do the hard work of putting meat on the bone. And so they just throw the bones out there and mostly they let the executive branch do it, which is not the executive branch's authority, really. Except that Congress cedes it to them.
They do, and it's all a bunch of unelected, well, I think it was George Wallace that called them pointy head bureaucrats.
Mm-hmm.
And that's why the pandemic got handled like it did. Congress didn't do anything. Right? They just stood back and let the pointy head bureaucrats make all these terrible decisions because they wrote laws that said, during hard times, we're going to give the Department of Health and Human Services the authority to issue regulations on how we should handle things, and we're done.
Well, I find it amusing. I'm waiting for the same leftist media, and I'll characterize it that way because that's what they are. But certainly narrative-driven media that have suggested, out and out said over the last couple of years, since Dobbs, really, that this is an extreme court, that they're acting extracurricular to the Constitution, that they bow down before Donald Trump, do whatever Donald Trump wants them to do. Where's all that talk after the last couple of days? The abortion pill case, Jay, say what you will about it, 9-0.
Listen, man, there have been a lot of 9-0 decisions out of this court. You don't hear anything about that, but that everyday blocking and tackling that's going on. This court has been unanimous or nearly unanimous in a huge number of cases this year, one of which my firm recently won this week.
Oh.
Yeah, I'm very proud of that.
How about that?
It was a pretty significant case involved in the National Labor Relations Act because, it's technical, legal, union stuff. But, we got a big win in that case.
I didn't realize Littler was a part of that. I just saw the headline. I promise I didn't read the details of the case because some of your work gets really boring really quick, Jay. I know it's important, but
Yeah, it does. Well, I'll tell you what it was about. It was about a Starbucks in Memphis, where it closed at 5 o'clock. Well, they were trying to get union in there, man, and so they arranged for the local TV station to come into the Starbucks after it was closed, and in violation of all kinds of security regulations they have, and come in and interview the people and whatnot. And well, they got fired. And then they filed charges, and I went up to Memphis and took the deposition.
Oh, did you?
So-called Memphis 7.
Uh-huh.
Yeah. And then that case ended up in the Supreme Court. Oh, it just occurred to me.
You've argued too.
I can now claim two.
You can now claim too. You were part of that case. Yeah, there you go.
That's funny.
Wow. Well, hold your water here. I want to talk to you about the abortion case in just a moment. It was a 9-0 decision, but I want to get Jay's analysis on exactly what happened there. And we'll also talk with him about a few other legal matters and your telephone calls and your super text. If you have a legal question for our man, Jay St. Clair, it's now the time. It is Fri Jay on Super Talk 99.7 WTN. I will not throw Jay Harper under the bus, but I will throw Belle K under the bus. They let me down. It's Melanie Layden. Now, I was saying melody, and it's not melody. It's not like a song. It's like Melanie.
I was saying melanin, so whatever.
And a lot of you listeners, Melanie Layden, you're telling me that she is a fine meteorologist, and I'm sure that she is. And WSMV4 meteorologist Melanie Layden is with us this week because Stefano DiPietro is getting married this week, apparently. So I would encourage him to.
He's having his nuptials right in the middle of a death-defying heat wave. Mm-hmm. That shows his commitment to the job.
would encourage him to take his wife's name so that we can get rid of that last name.
And wear some loose clothing.
Loose-fitting clothing during the marriage.
Stay hydrated.
Right, because there's extreme heat going on. It's like 92 degrees. All right, so here's, I just want to read this because it's so good. Jay, before we move on to anything else, and I have to ask you about some of the after effects of the Hunter Biden thing, too, but I just want to read this from Justice Alito. It was sent to me, and I think you got a copy of it, too, by our good friend Richard down in Alabama. Right. And it's just so good. And this is the heart of the matter when it comes to courts refusing to do things that legislatures ought to be doing. And right. Justice Alito says, I join the opinion of the court because there is simply no other way to read the statutory language. There can be little doubt that the Congress that enacted 26 U.S.C. 5845 would not have seen any material difference between a machine gun and a semi-automatic rifle equipped with a bump stock. But the statutory text is clear, and we must follow it. The horrible shooting spree in Las Vegas in 2017 did not change the statutory text or its meaning. That event demonstrated that a semi-automatic rifle with a bump stock can have the same lethal effect as a machine gun, and it thus strengthened the case for amending 5845. But an event that highlights the need to amend a law does not itself change the law's meaning. There is a simple remedy for this disparate treatment of bump stocks and machine guns. Congress can amend the law and perhaps would have already done so if ATF had stuck with its earlier interpretation. Now that the situation is clear, Congress can act. How well said.
You know, you asked me one time years ago, man, what is an activist judge? And I remember I answered you kind of flippantly. I said, well, it's one that rules against me.
Mm-hmm.
You know, that's what a lot of lawyers think. This is the opposite of an activist judge. An activist judge is a judge who interprets the law to be what she thinks it should be. Whereas a strict constructionist, or, you know, whatever term you want to apply to it, interprets the law as it is written. It's not judges' role to write the law. It's their role to interpret it. And Justice Alito said it just right. It said that's the opposite of an activist judge. There's three branches of government, man. And he knows how to stay in his lane. Congress needs to do their job and quit deferring everything to the unelected administrative part of the government.
Amen. That's well said as well. All right, we'll get to the Hunter Biden piece because I do want to ask Jay about the Second Amendment implications and whether or not Form 4473 can be challenged on Second Amendment grounds. We'll deal with that in a moment. It's 1:31 on Super Talk 99.7 WTN. We've got a number of questions on the membersnutrition.com super text line. Before we get to those, however, Jay, I will ask you this question. I don't know how much, obviously Hunter Biden was found guilty on all three charges against him. The Biden defense, and there's some question about whether or not the judge precluded a Second Amendment defense early on in the trial. I don't remember that, but my good friend Cameron Smith indicated that might have been the case. But, and so they went with a different type of, their defense seemed to be more that he wasn't an addict at the time that he filled out the form. And the prosecution in the case, obviously demonstrated that he, in fact, was, and the jury agreed with the prosecution. My question for you, though, is for me, it's a pretty obvious open question to the court as to whether or not this Form 4473 in some way violates the constitutional rights of law-abiding citizens with regard to gun ownership, especially considering that now we have different opinions from the various states about what is and is not legal with regard to the consumption of drugs. So the question at hand is from 4473, question 21, number F, which is this. Are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? And then it says, warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside. Mm-hmm. And I don't think that's constitutional.
Well, the question is constitutional. You're saying that if somebody answers yes and they're denied the right to own a gun, that would be unconstitutional.
Yeah, I'm pretty sure that I'm safe to say that a yes answer on that question would be an automatic denial for you to purchase a gun. I believe that's the case.
Well, let's assume that's true for this discussion.
Okay.
Here's the way I think the Supreme Court would evaluate that question. It's a really fascinating issue. I hadn't really thought about it until this moment. But Heller and the other cases, and a lot of the way the current Supreme Court is looking at things, is what did people understand? What was the common understanding when the law was passed? That's what helps us understand what it means. And that's why in the Second Amendment we get the idea that the private ownership of guns is protected by the Second Amendment. Mm-hmm. Because that was the case when they passed that amendment to the Constitution. So I think what the Supreme Court would do, Matt, is they would go back and look in history in the late 18th century and say, were habitual drunkards prohibited from owning a firearm? Were there laws back then that said that Otis Campbell cannot own a gun? Now, Bill, that was fun. That's a very good example right there.
He's the hey, Bell, you know enough about the Andy Griffith show. Mm-hmm, you know the only regularly recurring character on Andy Griffith that was married?
It was Otis.
Yeah. Who was the town drunk again?
Otis.
Okay, thank you.
Jay, you're forgetting the fact that we had an entire episode of the town drunk buying a car.
Oh, yeah. Yeah, the little town I'm from, Dunlap, Bell, is so small we didn't have a full-time town drunk, so we all had to take turns.
Let me know if I can help.
Jay volunteered on the weekends. That's what I understand.
I honestly don't know what the laws were like back then, but I think that would be a very important fact in how the Supreme Court would decide that question.
Well, and I don't know, and I admit that I don't know that the specific question about Section F has ever come up, but I have learned enough from you that commas mean things. Words like or mean a lot when determining this type of thing. And so for me, are you an unlawful user of, comma, or addicted to, comma, marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? And so then the question becomes, are we talking about just unlawful stuff, or are we talking about unlawful stuff at the beginning and then everything else at the end?
Yeah, or I'm reading that kind of as an either or. You're disqualified if you're either doing it unlawfully or if you're doing it, if you're addicted, even if it's lawful.
Right. That's the way I read it.
This is just a shot in the dark, man, because I don't know. But I bet you the state of the law back in the colonial times was Otis Campbell couldn't carry a gun. They'd take the gun away from the town drunk. But if somebody, held it to moon once a month or so, I think they get to keep your gun. So I bet you it's presumably that the Supreme Court would say that occasional recreational use of even illegal drugs doesn't disqualify you from owning a gun. But if you're Otis Campbell, you can't have a gun. And don't get suckered into buying a cow thinking it's a horse.
I got a giggle out of it.
Yeah, that episode was on the other night.
Well, that's funny.
Jay, we got a lot of questions coming from the peanut gallery, as you might expect. And as soon as I get over to them, I will get to a few of them. They're loading here. And this one's sad, and I'm sad for 6964. I don't have a name here, but 6964 writes that my son passed away unexpectedly May 18th. I'm sorry to hear that. Hospital sent him home in March after a week's stay with blood sugar over 1100. He was in the ICU for 2 days.
Wow.
Got his sugar down, but sent him home with sepsis. Only way he found out was by looking up a medication they sent him home with. I have a video from April 10th with him saying he was dying. Wow, this is sad. For us to sue the hospital and send his son to college, do we have a potential case? Of course, we are currently waiting on the autopsy report. What would your advice be here, Jay?
Yeah, no, absolutely. You need to get in touch with a very top-flight medical malpractice attorney as soon as you can. Medical malpractice is a very specialized area of the law. Don't call somebody that advertises on television. You need to get with the very best, and I can put you in touch with that person. Well, no, I shouldn't say his name a while ago, but if you will, my contact information, my office contact information is on the internet. That's J. St. Clair. I'm more of a sinner than a saint, but my name is St. Clair. Just Google that and then shoot me an email or call me, and I'll give you the name of the attorney. The guy I have in mind is in Alabama. He practices really across the nation. Mm-hmm. If he thinks somebody in Tennessee would be better, he'll send. He's that kind of a guy. Mm-hmm. He's so successful. He doesn't need anything that he's not the right person for. You need to get in touch with the very best medical malpractice lawyer you can as soon as you can.
All right, so 6964, find Jay, and it's JAYSTCLAIR. If you look him up, you'll find him. He comes right up on the top of the page. And if you have any trouble, 6964, just hit me up, and I'll get you his email information and his telephone information at his office. That's just a very sad case. From that to this, I mean, this is the way we do it on the Matt Murphy Show. 4209 writes and says, "Hey, Jay, if I'm peeing on my lettuce to keep my deer away, and my neighbor walks up to me at night, am I indecent?" Look, I don't write them. I just read them. Don't give me that silence.
Well, I'm just wondering why he thinks that human urine is going to keep deer away. That's odd. Because I think sometimes hunters buy stuff. They buy deer pee. So I can tell you all about this because my grandfather, we preferred doe meat as opposed to buck because Pa believed it was it tasted better. It was more tender. Right. And
when we would kill a doe during doe season, and we would dress the deer ourselves, at home. We didn't go to any fancy, machine, packing plant or whatever. Right. And Pa was very, very serious about protecting the doe's bladder so that we could keep the pee, Jay.
Oh, well, of course, that's going to attract bucks.
Exactly right. That was the big deal. So, yeah, you cover up your human scent by putting, my grandfather would regularly, during my childhood, douse me in pee. That's what he did. Doe pee, but pee nonetheless. So,
is there a Russian video?
No. There's some folks wrote it down in the dossier. But
here's the answer. So anyway, here's the answer to this question. If you're not on your property, yes, there's nothing you can say about that. You can't walk around. Well, I wouldn't say naked, but let's just say exposing your private.
Mm-hmm.
Even if you're on your property, if you are within plain sight of people not on your property, then yes, I believe that to be indecent exposure. Doesn't matter whether you're trying to run deer off or if you're getting your kicks. If you're walking around, even on your own property, naked, where other people can see you, then that violates the law. This is America, sir. This is not, outer Mongolia.
Apparently, this is born of a conversation with our good friend Cameron Smith, who was filling in for Chris Hand earlier. They were talking about keeping deer away from garden vegetables. So apparently that was a question born of that. I know it reminds me of there was a local, you remember the show Cops?
Oh, sure.
Remember Cops, sure. Montgomery, Alabama produced a local version of Cops on their local Fox affiliate.
Yeah, I think I remember that.
And there was I will never forget it. There was a call for an obscenity call in Slapout, Alabama.
Yeah.
And the police went to the call, and the call was that there was a man naked in his front yard going to the bathroom, peeing in the front yard.
Yeah. Right.
And the police went to his front door and knocked on his front door, and the guy came to the front door. And they said, "Sir, we've had a call about someone naked in your front yard." And the guy said, "Yeah, but I wasn't peeing."
Well,
that was true. I saw that with my own eyes.
That's funny. You remember the guy, I think it was here in Alabama, where the guy went to the Bass Pro Shop and he couldn't stand it, so he took his clothes off and jumped in the big aquarium.
Yeah. And at first we thought, well, that guy's a little crazy. I mean, I guess you got to be a little bit crazy.
Yeah. Right.
But apparently he just wanted to get in with the fish.
Yeah. Yeah, so that's right. You cannot expose yourself, even on your own property. You can't walk around your property line. You can't say, "Well, I'm on my property." Well, it doesn't work that way. I mean, you can't do that.
Well, Jay, on that front, we're going to leave it right there. I had such a good time with you last week. Thanks for being my friend, and thanks for letting me win once or twice a year at golf. I appreciate it.
Well, you won that one fair and square. I mean, I tell you what, you coming along.
Well, I don't know. I have no idea. Erica asked me. She said, "Did you do okay?" I said, "Yes," and I have no idea how, but it happened.
Well, it's funny because you weren't thinking anything about it. You shot 83 on Saturday, and you're wearing my phone now. So, hey, Jay, let's go play golf.
Oh yeah, I'll wear you out when I'm doing well. You know me.
Well, I'm looking forward to our next trip over to West Tennessee.
We'll do it soon. Take care, my friend.
Thanks, buddy.
There is our legal correspondent, life consultant, all-around good guy, and gambling buddy, Jay St. Clair. It's 52 after the hour on Super Talk.